Good morning. I'm Martha Minow, and as the Dean of Harvard Law School, I get to introduce many events, but I don't know one that we've done in a long time that's as important and significant as this one. Capital punishment and the practice of it in the United States has made us, I think, an outlaw nation. And the work that will be discussed here today will explore in so many different ways how we got here and where we're going. It is with great delight that I welcome everyone here. I'm particularly grateful to those who have traveled. This is the all-star team at a time in the country when many of us are not particularly happy. It's important to focus in on what really needs to be done, and this is an area where very important work is happening. I am particularly delighted to see the program focus on this crucial book by Carol and Jordan Steiker. And I know that they will tell you how grateful they are to so many people here for the work that it reflects and the work that I hope it helps to continue to mobilize. So it is with great pleasure that I say welcome, and I also want to underscore how the program that is sponsoring this is a vehicle, I think, for work, for policy, for scholarship, and look forward to many, many ways that you all can be involved, stay involved. And I say thank you. And now I get to introduce Carol, who is unbelievable. You all know Carol. Carol has, with force, elegance, and precision, and with the terrific collaboration with Jordan, worked on this topic for a long, long time, convinced the ALI that doesn't get convinced of many things, and also produced a book that is magnificent. And Carol, would you come and welcome everybody here?
Thank you so much, Martha, for your support of our program and your support of our book and your support of me. Thank you, my dean. I, too, as Martha predicted, want to welcome you all to Harvard Law School. I want to welcome you wearing a number of hats. One is as faculty co-director of the Criminal Justice Policy Program that is sponsoring this event. So Alex Whiting is my co-director. And Larry Schwartztall is our executive director. This is our second year of full operation, and as many of you know, we run a variety of events, speakers, and projects around the law school, and we hope that some of you will come to see other things that we do and engage with us. You'll also see staff of the Criminal Justice Policy Program assisting today, and students from the Criminal Justice Policy Program sitting outside at that desk outside. So if you have any questions about our work, we'd love to hear them and encourage your future engagement with us. Obviously, I also wear a second hat as a co-author of the book that gave us the idea to host a conference around this topic. Our book was just published, and it's just such a privilege, a humbling privilege and honor to invite so many of the people whose work as scholars and as lawyers motivated, inspired, and challenged our own thinking. And to have them all together in a room for a day is just a singular privilege for us. And I also think you'll find for you, because they are such a knowledgeable and wide-ranging group of thinkers and doers. So just to give a sense of what the day holds, your panel program reflects there'll be 4 panels that are moving outward in level of generality. So the first panel will be specifically discussing our book and the themes that it raises. The second panel will be focused on the issue of race and capital punishment in America. The third panel on the death penalty in the context of the broader criminal justice system. And the final panel about the Supreme Court's constitutional regulation of capital punishment in the context of its attempts to constitutionally regulate other highly contested social issues. So we have an incredible range of people who will be speaking. And today at lunch, which requires pre-registration. So if you've pre-registered, you're welcome to join us for the lunch. The rest of the panels, there's seats, and you're welcome to walk in and out of, whether or not you've pre-registered. We'll be doing a Q&A with Donald Verrilli, the Solicitor General from the Obama administration, who's well known to many of you here today. So we'll be hearing from him at lunch. Each panel is an hour and a half. There'll be a 15-minute break between each panel, and we hope to see many of you throughout the day. So I think I will turn over now the moderation of the first panel to Alex Whiting, Faculty Co-Director of the Criminal Justice Policy Program.
Thank you, Carol. Good morning. My name is Alex Whiting, Faculty Co-Director, Moderator. My job is going to be to stay out of the way and let the panelists speak. I should tell you that the event is being live cast and recorded. Therefore, you're put on notice that if you speak, you are being recorded. I'm not going to do tell you the bios, because you have the bios of all the panelists in this little booklet. And I want to save time and give the panelists as much time as possible to speak. By prior agreement of the panelists, Mr. Michael Meltzner is going first.
3 minutes ago. Can you hear? Everybody hear? I lobbied to go first because I wanted to channel my favorite baseball player, Dustin Pedroia. And with a lineup like the rest of the day, I thought that was the best way to handle things. A trigger warning. I may read a few things, and I might get a little personal if that troubles anybody. In 1872, Leo Tolstoy wrote a short story called God Sees the Truth, but Waits. In the story, an innocent man is convicted of murder, sent to Siberia, and only obtains proof of his innocence after 26 years in prison when the real killer confesses. The last two words of the title, but waits, are really the most important. Tolstoy's telling us that we have to be patient. Justice will eventually emerge, even if it takes a long time to manifest itself. Now, our world is not really known for its patience, but of course, given the results of the election, we're going to have to be patient. We're unlikely to be near a Tolstoy metaphoric number, 26 years. In our case, the number is closer to 40, unless Anthony Kennedy sees the true cross in the months ahead, and that is, of course, very unlikely. Despite the recent impact of lower execution rates, more abolition states, changes in jury behavior, and so on, well known to everybody in this room, the presidential election and votes in California, Nebraska, and Oklahoma tell us there's a long way to go. But for abolition to ever arrive, we still need 5 votes, and before there are 5 votes, there needs to be a persuasive theory. In our system, even those who have strong doubts about the death penalty need reasons that they think make sense to a larger constituency. In my judgment, the greatest achievement of courting death, and there are many, is setting out in calm, reasoned fashion the total failure of the court's decades-long effort to regulate consistently and fairly how the sanction has been applied in fact. And by giving us a roadmap the court can follow to get rid of it, I'll call it the Steiker entry in Google Maps. This being the 54th year in which abolition of capital punishment has been a large part of my professional life, I know something about patience. I also tend to spend probably too much time thinking about the past. One early morning in 1968, I arrived at the NAACP Legal Defense Fund to find a draft of an amicus brief on my desk, a Supreme Court case called Boykin v. Alabama. Edward Boykin had been convicted of 5 robberies and sentenced to execution in all 5. Now, in the 1960s, there were 9 states that authorized the death penalty for robbery, but only Alabama did so for the crimes that Boykin was convicted of. He was convicted of simple robbery, not any forcible one. The draft on my desk was written by Tony Amsterdam. He disappeared from the office 3 days earlier, which was not really so unusual, as he moved around a lot. He was a full-time faculty member at Penn Law School. He was a legal guide to whoever could find him. He would get letters from all sorts of lawyers around the country and end up writing 3-page answers, single-spaced, with footnotes, which the lawyer would often convert into a motion or a brief. And he was also, of course, an LDF consultant during these critical years. But I talked to him almost every day, and I really wondered what he was up to, and it was this amicus brief he was up to. Actually, at LDF in those days, it wasn't so strange for me to find a brief on my desk when I arrived in the morning. My dear colleague, Jim Nabrett, the greatest civil rights lawyer you've never heard of, would often also disappear, and he would provide stuff in the morning, and he called it going lunar. That was the way he described his work habits during the 60s. Well, we know for certain that the justices read the Boykin amicus brief, though the case was decided on the way his guilty plea had been entered. The death penalty argument that was made there by LDF was ignored. But the core argument in the brief was significant. Let me quote a summary of it. The issue in the case is, really, will contemporary standards of decency allow the existence of the law's penalty in fact, drawing the distinction between what the public conscience will allow the law to say and what it will allow the law to do. This formulation is essentially the basis for the decisive grounds for the result in Furman v. Georgia 4 years later, randomness and arbitrariness. In Evan Mandery's wonderful book, A Wild Justice, the Boykin case is in the index 25 times. That gives you a sense of the importance of this argument. In short, it was an act of intellection by a law school professor that ultimately produced the doctrinal support that saved 600+ lives. And I submit that's what we have in courting death, an argument that the court's recent proportionality decisions is a major way to support and justify an end to the death penalty, is what we find in the book. Now, some say I shouldn't compare Carol and Jordan's work to Tony's because there are 2 of them, and they have an unfair advantage. But I always thought that Tony Amsterdam had divine intervention, and so he had his own partner. To sum up, abolition may not happen tomorrow, but for it to have any chance at any time, we need careful scholarship and accessible and persuasive arguments to get us there, and that's what we have in this wonderful book. A last point or 2. I've been asked by Lincoln to comment on the following, and I quote him. The reason for the Inc. Fund's involvement was racial discrimination in the application of the death penalty. Yet the Supreme Court went out of its way to avoid accepting that view. How does the Inc. Fund strategy then look to you now with this discrepancy in mind? Well, here are my answers. First, we have to distinguish between motivation and strategy and tactics. Yes, we got into the issue because of race. That's what LDF was about. But we would accomplish our goal of ending racial discrimination if we got rid of the death penalty. It would certainly have been better if the court found the race issue, dealt with the race issue squarely. But almost from the beginning, when the final draft of Justice Goldberg's courageous Rudolph dissent incredibly failed to mention race in Southern rape cases, we argued whatever we could. There were lacking standards, there should be a split verdict, the jury selection process was skewed, and so forth, whatever we thought would win a case. Carol and Jordan's chapter on race really stands as the definitive statement of the whys of why the court avoided the racial issue. To it, I would only add two comments. One, close to what they say, a second point, what I believe and add. First, to use race to get rid of the death penalty in the 1960s and 70s, the court would have been accused of claiming that thousands of American jurors were racist. There would be no escaping that conclusion that they had sent men to death because of the color of their skin. The statistics were overwhelming. Certainly many of the jurors in question had expressed bias, and others had probably implicit bias. But with the civil rights movement, victory's fragile, and the country subject to incredible urban rioting, the justices were just not able to take that step, more plainly for political than legal reasons. The second reason for avoiding overwhelming evidence that race affects capital sentencing is more sinister. It expresses the same flaw that is found in the Brown v. Board of Education opinion, an unwillingness to name the sources of discrimination in beliefs in white superiority. As Randy Kennedy taught me a long time ago, Chief Justice Warren just wanted to be non-accusatory. He thought that was the way to go. Well, we're taught that even if we savage judges for the lacks of their opinions, we should do so respectfully. And I couldn't agree more. I reached my ultimate conclusion with great hesitation. But after 40 years of decisions ducking or minimizing the issue, the behavior of the justices with respect to the intimate connection between race and criminal justice that concerns us here today strongly suggests that to a majority of the justices, over time, it's not that Black lives matter or that Black lives don't matter, but that Black lives just matter less. But I'll repeat that. Looking at over 40 years of capital punishment decisions, the only explanation I find for the court's behavior is that Black lives just matter less. Thank you for your attention.
Next up, we have Evan Mandery.
Well, I'm just going to say, when my book came out, we went to IHOP. I recently read Charlie and the Chocolate Factory to my daughter, which was my favorite book when I was a kid, and my favorite movie, the Gene Wilder version, bless him wherever he is, and not the Johnny Depp version. And I reread it to her, and I was horrified. I think I had read it 3 times as a kid, and I was like, oh my God, it's anti-child and a little bit anti-Semitic. And you see how your orientation to a text changes. As an author, it certainly changes. You can go back and read something you wrote and it has a totally different meaning to you. And I can only imagine how these authors felt, because about a month after I read the book, I went back and looked on page 322 at the sentence the United States has not traveled along a well-trod path toward a predetermined destination. So that sentence has tremendously different meaning. I'm not feeling as optimistic as Michael is these days. My family isn't all white males, so they're feeling pretty vulnerable. And where I teach at the City University of New York, there are almost no white males. I've been speaking to hordes of crying students over the past week, and so I hope you're right. But he sent me an email telling me to be patient, and I love him and trust him, so I really hope he's right. But we can celebrate, regardless of where we're going, an extraordinary scholarly accomplishment by two formidable and I would say definitively authoritative scholars in this field. I was looking over and briefly chatting with Karina. I remember the transformative moment for me in my thinking about the death penalty and what my scholarly direction would be, and it was reading Carolyn Jordan's article, Sober Second Thoughts, which I guess now is 20 years old or so, which is looking at the Supreme Court's regulatory project and trying to evaluate it. And what was so striking about it was that whereas everything I had read to that point was so clearly polemical, they took the court at its word and made a very serious academic effort to evaluate it. And I thought, wow, that seems like something scholars can really contribute to. So I don't know whether that was the right question for the Supreme Court to ask, but it's a legitimate question to ask whether it can curtail arbitrariness. And now we can try to empirically and qualitatively assess whether that's happened. And they preliminarily concluded that it hasn't, and I think they've conclusively refuted that we've made any progress in that direction. But I thought the scholarly project was so transformative, and I've been able to read, fortunately, almost everything that they've read over the course of their careers. And individually or collectively, what they've done is taken each component issue in the death penalty and analyzed it on its own merits, and with a lot of objectivity. So they have articles on why the cost argument has emerged in the death penalty movement and evaluating on its merits. What's the moral and legal relevance of deterrence? And they don't always, to their credit, reach the same conclusion. One of my favorite pieces that they wrote is an article, it's in the Journal of Criminal Law and Criminology from 2005, questioning whether the abolition movement's focus on innocence has really been well-placed, and asking whether or not that opens the door to a very narrow response to capital punishment, which is to say if we can just deal with the problems of mistaken convictions or correct them, that capital punishment wouldn't continue to be problematic. And obviously for those of us who have studied it, right, that it still doesn't get at any of the problematic underlying dynamics, particularly race. And I second Michael's motion that I think their chapter, and they also have an article analyzing the invisibility of race in the death penalty argument, is really definitive and extraordinary. But so in a general sense, whatever one thinks about the death penalty, and guessing this isn't a randomly selected audience of Americans, but I think their independence and their ability to deal with arguments on their own merits, especially in the context of an issue that almost always fosters such passion in people and in scholars, is really something truly to be celebrated. I see this book as an extension of that seminal article, which Karina and I were talking about. And by the way, Karina's article, Furman Fundamentals, is really another great, if you're going to, it's on my short list of 2 or 3 articles, law review articles that I would read. Wow, I got an awe. That I would recommend to folks if you wanted to kind of get a general orientation to this field. And so Sober Second Thoughts is exploring the consequence of the court's regulatory enterprise. And what they do a really fine job at, probably most of you know, but 2 notable facets of the court's project. One, the fact that the court is in the business of regulating the death penalty at all. And second, the particular form that regulatory enterprise has taken, which is to simultaneously say that states have some, but not very much, burden to set up a system that attempts to curtail arbitrariness, while at the same time preserving the possibility of individualized sentences in capital cases. And for those of you in the field, you know, Antonin Scalia's famous quote about the tension between these two objectives. Let's just say it's minimally very difficult to accomplish. But before I talk about their contribution to analyzing the effects, just want to draw out something that they do a really fine job in the book of, which is to show how accidental that regulatory enterprise is. And there are a half dozen or so historical flux points in this story where a very arbitrary or hastily arrived at decision could have sent the history down a totally different path. And I'd actually nominate last Tuesday to be the most recent addition to that list. Michael was talking about Boykin, and maybe even if you've taken a death penalty class, you might not have read Boykin. You might not really know about Boykin, but Boykin, to me, was the moment that set this history down a different course. So if the Supreme Court had remember that Michael and his colleagues at LDF didn't set out to bring a blanket Eighth Amendment challenge against the death penalty. They wanted to bring individual challenges, individual constitutional challenges to the death penalty that would slow up the system, and by pooling so many people on death row, ultimately force the system to collapse under its own weight. And I think it was the right strategy. Boykin ends up being disposed of on Witherspoon grounds, right?
Guilty plea.
Guilty plea. Maxwell's decided on. The last time I asked him a question, we ended during when I was speaking, we debated whether Sandy Koufax or Jackie Robinson was the best Dodger, right? So my mistake. Anyway, Abe Fortas's resignation. Yeah. Abe Fortas's resignation, right, which is just kind of a historical accident. He's forced to resign over something that the Supreme Court justices routinely do hundreds of times a year now. Ends up setting the path down a different course, which is the cases are decided after Harry Blackmun joins the court, and of course Blackmun isn't Blackmun by this point in McGatha. The issues are these procedural issues are disposed of, and even at this point in 1971, where the Supreme Court disposes of McGatha, it isn't inevitable that the court will hear an Eighth Amendment challenge, and in fact, it's such a random, if you're looking back on it, random event that precipitates the court to take an Eighth Amendment case, which is Hugo Black, who dies approximately 6 months later, argues that the court needs to tie up this loose end. He's completely confident that the Eighth Amendment argument is going to be resolved in favor of the death penalty. The court hears Furman. We have Harlan, and Harlan departs from the court along with Black, which maybe liberates Stewart a little bit. And before you know it, you have a 5-4 very bare majority in Furman. But even still, the course of the regulatory enterprise isn't set. At the last, if you've read my book, you know there's this kind of last-minute deal between Potter Stewart and Byron White, and Potter Stewart is inclined to make a moral statement against the death penalty, instead makes a compromise with White where he says that the problem is the application of the death penalty, opening the door to these revised statutes, but committing the court to be in the business of regulating if the court ever decides that the death penalty is coming back. Obviously, there's this massive backlash. And what's so striking, when I tell this story, it's the 1976 cases are decided over the course of a lunch, and that might be slightly dramatized, but I don't think it is by very much. I found no evidence in the historical record whatsoever that Powell, Stewart, or Stevens really thought through the consequences of the path that they set the court down, which was, on the one hand, to say we're going to be in the business of regulation, and on the other hand, because their stomachs didn't allow them to commit 100% to this thing that they all had deep misgivings about, to say that we need to preserve the possibility of individualized sentencing. And those twin paths they turn out to be irreconcilable and failures, but just want to emphasize that there was no project. I think you'd like to think, well, there was a moment where they sat down and said, this might be a tough row to hoe, but we think we can do it, and here's the way we're gonna approach it. And there's no evidence whatsoever of that. Now, where I think the book is extraordinary is in talking about how accidental the consequences, how accidental and unforeseen the consequences of that accidentally constructed enterprise were. And it certainly, I don't think, Stewart, Powell, or Stevens thought for a second, wow, this is going to impose huge costs on the system and lead to delays. And by the way, some of those consequences may have had the opposite effect of what they were hoping for. If they were, and substantially undermines, at one time creates a veneer of reliability that there are procedural mechanisms in place and gives some people some sense of confidence that the Supreme Court has gotten involved. They conclusively show that this is a sham. And at the same time also undermines the death penalty by creating these, I think, systemic problems that everybody sees as grossly problematic, the idea of people sitting on death row for 10 or 20 years. One more quote for your book. American abolition almost certainly will arrive, and I think we sat together, and I was on the really optimistic end of that, even a few months ago. So because of my, maybe it's just a temporary state of pessimism that will evaporate, or maybe will happily be proved wrong, but I'm not feeling confident about the unidirectionality of history's arrow today, but I am 100% confident this is an extraordinary scholarly achievement from the most formidable scholars in this very important field, and very glad to be here. Thanks.
Karina Lane.
You go. Huh? It's tied up here. All right. Well, first, good morning. And thank you so much to Carol and Jordan for including me. I, too, think this is it's an extraordinary accomplishment. And after reading it the second time, I thought, it's not just an accomplishment, but it's a gift. It's a gift that they're giving to all of us. And so I want to celebrate it, and I want to thank you for putting in the hard work that is really the capstone of professional lifetimes, 2 professional lifetimes of hard work and careful scholarship. So I'm honored to be here. One of the things that I love about Courting Death is the way it seamlessly moves between the Supreme Court's regulation of capital punishment to the larger institutional settings in which that regulation occurs. And that setting, of course, has its own hydraulic pressures that move institutional actors in certain ways. And so I love how it combines all of that to give us a picture of what we're dealing with. And I'd like to spend my 15 minutes sort of looking at that system. It's a theme, I'd like to talk about a theme that is sometimes explicit in the book, sometimes more implicit, but it runs all throughout. And it's about the facades that permeate the administration of capital punishment, the capital punishment itself, that are built into the law and institutional design that allow actors at all stages of the process, from legislatures to the prosecutors, to the jurors, to the judges, to the governors, to the executioners and the execution team, to distance themselves from the death penalty and assure themselves that all is well, that the death penalty is being carefully administered, and that people are looking very closely at it. It's just not being done by them. So in a nod to Courting Death, I would call this disowning death. In Courting Death, Carol and Jordan talk about this phenomenon with regards to the constitutional regulation of the death penalty at length. And Evan and I were talking right before this, and I was saying to him, I was also going to mention their wonderful article, Sober Second Thoughts. I was in the process of researching my very first death penalty article, and it was Furman Fundamentals, so thank you, Evan. But I was researching that and came across Sober Second Thoughts, and I read it, and these certain pages where Carol and Jordan are talking about institutional dynamics those pages were so important to me that I copied the article, put it in my, my little library that I was building, and I copied these pages separately so that I could keep them in another place and continue to think about them as I went about my work. And so it was really sweet for me after I read the book to go back and say, oh, I've got those pages. I'm going to go back to that and what they said about that in Courting Death. And what they said there is, and in the book, in Courting Death, is that not only is the Supreme Court's regulation of the death penalty a facade, there's a whole lot of it, but it really doesn't do anything. But it's a facade that gives actors that are administering the death penalty a false confidence that there really is regulation and that everything's okay. And it's not just those actors and the effects that it might have on them, but it's the public at large too, and how that feeds into support for the death penalty itself. The public at large who would think, if anything, there's too much process. Capital defendants have too many procedural rights, get too many reviews. Let's speed this thing along here. And how that feeds into the larger system of death penalty support. And I just have found that to be profoundly true. And so as I was reading the book, I thought, well, that's true in other places too, not just with regards to the Supreme Court's regulation of the death penalty, this notion of disowning death. So I think about that, what they talked about there as sort of the alpha. And if that's the alpha, the other end of the spectrum, the omega, is executions themselves. And so I just want to spend a couple moments thinking about this theme of disowning death. And in some ways, they are at the opposite ends of the spectrum, in part because the Supreme Court's regulation of the death penalty is so sort of theoretical. It's the superstructure in which all of this occurs, and more general. And then at the other end of the spectrum, when you get to the executions, it's the most concrete. It's the most discrete. But yet this theme, this notion of disowning and assuring yourself that everything is well and it's being done very carefully, the notion of the facade that supports the death penalty itself is so strong here. So I've been thinking a lot about lethal injection, which has sort of gone away after or all of the attention on it has gone away after the botched executions of 2014. And doing a little bit of legal history work on it. And what was striking to me is that lethal injection was brought in just after the Supreme Court decided Gregg versus Georgia. So there had been no executions in nearly a decade. There was a lot of talk at the time about televising executions. In fact, there was a suit in Texas. A federal district judge had said, yes, there's a freedom of the press right to televise executions. An appellate court had overturned that, but who knew what was going to happen? At the same time, there had been a number of botched executions with gas. People were fainting watching those executions. The electric chair, the same thing. And so people really saw that as barbaric and an anachronism. And in fact, at the time, people were talking about Gary Gilmore's execution, which was in some ways clean, and in other ways very messy. But they were talking about how there was a public outcry after that, and how they were worried about Gary Gilmore being this martyr. And so what was interesting to me is how legislators did not say, gee, if we want to make this more humane, what do we do? How do they put down pets, by the way? We've been doing that for decades. What do we do in the Netherlands? They didn't ask that question. If you look back at the legislative history, what they were saying is, we've got a real problem here. America hasn't seen an execution in like nearly a decade, and the methods we have are very disturbing. And one particular legislator's quote was moving to me and kind of sums up the whole thing. He said, we don't want jurors thinking about someone sizzling in the chair when we're asking them for a death sentence. We need to figure out a way to make this palatable. And so there you have it. And there's this whole conversation one might have about whether lethal injection is in fact humane, but I think that there's really good reason to believe, based on the historical record, that that's sort of incidental. That the chief benefit of lethal injection is allowing us to not think about the death penalty as a violent act because the violence is internalized. As As one Department of Corrections official put it most recently, the goal is to make what you see as non-eventful as possible. We want executions to be a non-event, so we don't have to think about them as violent, or maybe we don't have to think about them at all. As Judge Kaczynski said, the thing about the drugs is it's a mask. So I think that there's something to recognizing the death penalty is inherently violent. And I think there's something to recognizing that lethal injection hides that fact and was adopted for the very reason of hiding that fact, to make the death penalty more palatable. It's the facade that's doing the work. And then I thought, in reading the book Courting Death, you see these themes all over. It's not just the alpha and the omega, it's everywhere in between. And Jordan and Carol do a marvelous job of interspersing their discussion of the Supreme Court's regulation with the larger institutional dynamics that support disowning death. So I thought it was really interesting that they talk about in the book these moments of responsibility. They call it moments of responsibility. These opportunities for actors within the system, institutional actors, to put a wrench in the machinery of death, and how every actor has to go along to make the system work. But the truth is, by law and institutional design, the law and the way the system is made up is really tells those actors actually just the opposite. This is not a moment of responsibility. It tells those institutional actors the responsibility lies elsewhere. It's not really with you. So there's this false impression at all different levels that the death penalty, a very careful decision is being made. It's just not being made by you. So very, very briefly, I'd like to just talk about a couple of those examples that are interspersed in their book and think about the democratic implications of the point. In the beginning, there were capital statutes. And I think about Georgia's capital statute from Gregg versus Georgia, and how none other than Jimmy Carter signed that statute. And when he signed it, he said, I have grave doubts about the constitutionality of the statute, but I'm going to let the courts work that out. That's for the courts to decide. I'm just effectuating the will of the people in my state. And when Carol and Jordan talk about aggravator creep in the capital statutes, it's the same thing. The legislatures are saying, we're not saying there's supposed to be a death penalty for this or not. This is just enabling. These are just enabling statutes, enabling legislation so that the jury can decide. And then prosecutors say, look, aside from saying this is what the people want, this is what I was voted in for, the prosecutors say, look, I'm just using the statute. It's really for the jury to decide. So I was looking at this quote from Johnny Holmes from Harris County, and he said, as long as Texas provides for the death penalty, prosecutors have an obligation to carry it out, an obligation to carry it out. And then he said elsewhere, and by the way, anyone who's gotten the death in Harris County got it from a jury. Right? So it's not me that's doing it. I'm not taking responsibility. I'm just doing what the legislature said I should do, and it's up to the jury. And then you look at the jury. And Carol and Jordan talk about Robert Weisberg's work and how before Furman in McGatha, the jury instruction said, look, the law can't save you. I mean, in some ways, Robert Weisberg and Carol and Jordan say, in some ways, in some really sick way, it was better, actually, by way of taking responsibility for death before Furman, because in McGatha, the jury instruction said, you can't lean on the law. This is a profoundly moral choice, and it's yours to make. Whereas after Gregg, and with a guided discretion statutes, is exactly the opposite. And the work of the Capital Jury Project has proven that to be true. In so many cases, and I've looked at lots and lots of studies, but anywhere from 3/10 of jurors, 30% of capital jurors, to 50% of capital jurors, 50%, have said that they believed that the death penalty was actually mandatory in that particular case. It was required. So one woman says, quote, I'd like to think I would have voted for life unless this was a predetermined death penalty case, like felony murder. Yikes. And when you put this stuff together, 9/10 of jurors, 9 out of every 10 said, I was not responsible for the death penalty that the jury issued. And then Of course, you've got judges who say, we're actually not imposing death, we're just doing what the jury did, and the Supreme Court itself, which is using the same thing and then adding limited habeas corpus review, and the governors who are just executing the will of the people, and the executioners. And Mona Lynch talks about how here death is so real that there are special ways of disowning death. So it's this from start to finish, there's this entire process. And Carol and Jordan talk about the different pieces and how the Supreme Court's regulation of capital punishment works with those pieces and exacerbates this disowning. And we tend to think, well, everyone is responsible for this process, but actually what law and institutional design tell us is no one's responsible for the process. We have a system that kills without any killers at all. So I'd like to just take the last moment to just think about the democratic implications of the point. And I was thinking about how the death penalty today is justified so much on public support. And recently in Florida, the Florida Supreme Court just said unanimous, and this is in the wake of Hearst versus Florida, unanimous juries mean unanimous. And the Speaker of the House in Florida said that that was judicial activism that subverts the will of the people. And I thought about how many times that's been in the discourse. This is about the people, it's public support. And I'm thinking, it just doesn't work to have a death penalty justified in large part on public support that uses an execution method that intentionally hides what the death penalty is, because otherwise it would lose public support. And what's true of lethal injection is true of the death penalty more largely, of the larger system of capital system as well. It's this entire house of cards that tells everyone they don't have responsibility. They don't own it. Care is taken elsewhere. So courting death, which is the capstone of a lifetime of work that will continue, is wonderful in many ways, but I think what I love most about it is that it shatters the facade. It shatters the facade. It's a potent reminder of what this system is, of the Supreme Court's role in it, and it's an inspiration to us all to remember what the Supreme Court is doing, its role, and to continue the work of careful scholarship and the hope that it can make an impact as theirs has. Thank you.
Yeah, they're going to make, she's doing it right now. Lynn Kaplan, please.
So one of the pleasures for a reader of this great book is what a handsome volume the Harvard University Press made. And the quality of the book begins with the book jacket. The press, Carol told us last night at dinner, asked her if she had some thoughts about what might illustrate the jacket, and she proposed what you see here, which is a work by Andy Warhol called Electric Chair. Warhol in 1962 started to do a series of pieces that were about death and danger. And the next year, which scholars of Warhol's art say was provoked in part by the last executions happening at New York's Sing Sing prison, the last executions happening in the electric chair, he started a series of what ended up being 10 large electric chairs and some smaller ones. This piece is from 1971. Warhol was 43 when he made it. It's roughly 3 feet by 4 feet, and it's relevant to our story because it's the year before Furman, which many people thought was the end of the death penalty in this country, and then because of the response that it provoked, ended up leading to the reinstitution of the death penalty in 1976, and that's really the important frame for the heart of the story of courting death. And what's important about this work of art for this book, I think, is that it speaks to us in a different way from the text of the book. And it makes very clear, because of the arresting use of color, taking attention away from the chair itself, of the exceptional range of the book. What Warhol thought he was doing in this series was, by repetition, draining the chair of meaning and effect. But of course, it has an effect on us, and the common view of this from art critics is that it conveys the pathos of the chair waiting for the next victim. Dean Minow referred quickly to the report that Carol and Jordan were asked to do for the American Law Institute. And in many ways, well, their scholarship was enormously respected by then, and they were already thought of as the most influential scholars about the death penalty in the country. That report made clear the originality and the distinction and the importance of their work. And basically what happened is the American Law Institute, for those who don't know about it, is a collection of roughly 4,000 scholars, judges, lawyers, and some others who may be the last bipartisan group that is functional and influential, and have enormous patience in reconsidering aspects of the law where confusion and contradiction has overtaken logic. And the most important that most people know about is the Model Penal Code, which Herbert Wexler developed over a long period of time. He was the leader of the American Law Institute, as well as being a professor at Columbia. And the ALI had been having a debate internally for 10 or 15 years about whether they should call for a vote to call for the abolition of the death penalty. So the leaders of the ALI asked them to do this report. And what's striking about the report is the discipline and careful frame of it. So they gave some advice to the ALI. They recommended that the ALI not call for the abolition of the death penalty because the moral and philosophic argument that that would lead to would distract from the heart of the matter that they presented to the ALI, and that the disagreement across that spectrum was just so profound that they wouldn't get done what they could get done. And the ALI took their advice, and oversimplifying, it called for no longer supporting the death penalty as one option that a state could use for capital murder. And so their reputation was made as pragmatists. And it's not that pragmatism isn't a form of moral philosophy. From Bentham on, it certainly has been viewed that way, and Bentham thought of himself that way. But what's striking is that while this book makes essentially the same argument, which you've heard summarized, which is that the court has been involved in a 40-year experiment in regulation, which has failed. And since the standards of regulation were set out under the constitutional, they were constitutional standards. If the states are unable or unwilling to meet those standards, then the death penalty should be called unconstitutional. But even though this book makes that argument in a kind of fuller form, the book is distinguished in a number of ways for a reader that the Warhol piece, in a sense, signals to us from the first time we pick up the book. The book has an historical range. It has an explanatory power that make it an enormous pleasure as well as enormously educational for any reader. But the element that I want to focus on is the moral dimensions of the book. It's not a surprise that these would be embedded in the book in some sense to suffuse the book, given Carol's expertise in this area and the importance that it plays in Jordan's scholarship as well. But let me just focus on three dimensions that spoke to me as a reader and changed the way I understand the death penalty. So the first is the relationship between race and the death penalty. I'm not going to say a lot about it because there's a panel coming up that will focus on that. But what they make absolutely clear is that it's impossible to understand the death penalty as it's currently framed, as it's currently malpracticed, without knowing the roots of the death penalty in the history of slavery and legally sanctioned discrimination in this country. And they don't mince anecdotes. We understand the role that lynching played as a form of discipline, a form of sanction, informally and formally. It was shocking, but made perfect sense to me after I read their account that the death penalty was posed as the moderate alternative to lynching. That was one of the arguments made for it beginning in the 19th century, but into the 20th century. You can't understand the death penalty without understanding this relationship. And it's a profound moral argument that, in a way, has the silver lining that abolishing the death penalty would involve a reckoning with the original and continuing stain of sanctioned racial discrimination in our country. The second moral dimension for me was their premise about the failure that they set out. And the premise is that legal process has an integrity, that legal process has a capability of solving human problems in a way that, if you were oversimplifying what they stand for fairness. And again in the book, they go through legal process, whether it's how juries are selected or the gross ineffectiveness of counsel that the Supreme Court has implicitly sanctioned, and right to the vast overrepresentation of black men in the population who are on death row. All of the failures of process that are enablers of what makes the death penalty wrong as an element of American law. But what's striking is the optimism that it's possible for the legal process to do better, and if it can't do better here, then the lesson is that we need to stop this element of process. And there's nothing romantic about their optimism. This is a very hard-headed book, and they have a taste for and an acute sense of irony. And part of the failure they point out are the unexpected consequences of a choice in legal process. The third element is the hardest for me to describe, but I'll call it filial piety. The book is dedicated to their parents. The first person who is mentioned in the acknowledgments is Thurgood Marshall. And it's not unusual for authors to dedicate their books to their parents or to acknowledge a justice or a judge they clerked for who was very influential, but there's nothing conventional or dutiful about this acknowledgement. So this sense of the moral dimension from this filial piety is reinforced by the fact that this is the product of 24 years of working together. I couldn't find another brother and sister team who have done anything like this work in scholarship. Adele and Fred Astaire are the closest brother and sister team that I could come up with, and I guess I don't have to explain who they are. And what you see is so an extraordinary fact is that neither of them had thought a lot about the death penalty till they clerked for Justice Marshall, and yet the passionate center of their vocation has been this work. And what you see is them carrying on the work of the justice in some sense, which he did as a lawyer and did also on the court. But you also see the alertness to moral choices, the discipline of learning and teaching and collaboration, and the patience that it takes to do this kind of work that traces back to something that happened in the Steiker household. So all of this leads to a final dimension, which has a moral quality. Over the last 200 years, one of the things that American law has managed to accomplish is a kind of consensus that it's full of contradictions and it doesn't stand for truth. And legal scholarship has been beset by a kind of self-consciousness about this. And so one of the things that's remarkable about this book is that on Harvard Law School is about to turn 200. Texas Law School, where Jordan works and teaches, is about to be 134. And this is an illustration of what legal scholarship is about. It's about a patient pursuit of answers to very hard questions, and it leaves us with a kind of truth. And we've alluded to the presidential election. So far, our president-elect's stated views about the law range from cynical to contemptuous. And for me, one of the most gratifying things as a reader of this book is the inspiration it gives about scholarship, but also that for all of us more generally, the pursuit of this kind of mastery and moral clarity is a tremendous reward. So I encourage you to read the book, and I thank Carol and Jordan for it.
Great job.
So Jordan and I don't have prepared remarks, but we're going to each take a few minutes just to comment on the comments that we've received this morning. I have to say we're, overwhelmed by the knowledgeableness, the thoughtfulness, and above all, the generosity of the commenters here this morning. And just for students in the room, I know you've heard me mention many of the works that these panelists themselves have written that provide the food for thought that inspired us and engaged us as we were making our own contributions. So especially Mike Meltzner and Evan Mandery's books are a wonderful pair to read together. Mike Meltzner, one of the LDF lawyers who litigated all of these cases up to Furman and Gregg, wrote an extraordinary book that Jordan and I have multiple copies of, Cruel and Unusual, published in 1973, the year after the Supreme Court struck down the death penalty in Furman versus Georgia. And it's an extraordinary story of a constitutional litigation campaign from inside the lawyer's perspective on the many exciting twists and turns and the extraordinary victory. I love Evan's line in his book where he describes, we've stolen it and not always attributed it to you, Evan, but not in print, that describes the day that Furman was decided with a banner headline that was as large and as bold as the headline 3 years previously when a man landed on the moon. Now, Evan's book, A Wild Justice, tells the story not just of Furman, but of the end of Furman, the death of Furman 4 years later in Gregg versus Georgia, and its 4 accompanying cases when the Supreme Court reinstated capital punishment in the United States in 1976. But he tells the story. It's like one of those pair of children's books where you get like the story from 2 different perspectives. He tells the story from the justices' papers, many of which are now available, and we get the inside the court story of Furman and Gregg. So reading Cruel and Unusual and A Wild Justice together is the best introduction to the foundational constitutional cases of the Supreme Court's regulatory enterprise that I can imagine. You've already heard much about Corinna's work, Furman Fundamentals, an extraordinary orienting work. And of course, Lynn Kaplan didn't mention his own work, his many years of writing about the death penalty on the editorial board of the New York Times, his incredible piece, The Withered Writ, about federal habeas corpus. And I have to say, I'm particularly fond of the incredible article that he just wrote in Harvard Magazine about our book. Many more people will read that magazine article than our book. So we often say that our interest and the interest of the press is the press wants to sell our book, and we'll be happy to sell it to you. But many more people will read that article, which is just a really thoughtful exposition and engagement with the themes of the book. So we're incredibly grateful to this accomplished group, and for those of you who are actual students, or more metaphorically students of the death penalty, I commend you their work. Just a few comments on some of the substantive themes that came up. So, obviously we're, chastened in our sort of cautious prediction of a constitutional abolition of the death penalty by the events of last week. But on the day that the election was decided, another death penalty scholar took a screenshot, took a picture with his phone of a paragraph in our book that we had written and sent it around, because we were talking about how constitutional litigators, like Mike, when they're engaging in litigation campaigns, never know exactly when the right time to do things is and how unknowable that is. And we talked about the uncertainty of this whole thing in a way that it resonates somewhat differently after last week. So I'm just going to read you this thing that Doug Berman took a picture of. Said, we wrote this. These uncertainties attend all constitutional litigation campaigns. Advocates who win landmark decisions are often hailed as prescient geniuses, while those who lose are sometimes dismissed as fools. The truth of the matter is more complicated, because informed guesswork is a large part of the strategy of any constitutional litigation campaign, and serendipity is a large part of the outcome. As anyone who plays fantasy football knows, you can make choices based on reams of player information, but there are no guarantees that you will win big as opposed to lose your shirt. Yogi Berra said it best. It's tough to make predictions, especially about the future. So that's just a thought. I'll tell you one more thing. We wrote this book. Our first draft was due December 31st. Last year, and we predicted that if the court remained in its current political balance, that is, when Justice Scalia was still sitting on the court, or any appointments moved it further to the left, we predicted a firm to a constitutional abolition within 10 to 20 years. Then, was it February 14th, I think it was, Justice Scalia died, and we were still working on the draft. We changed it to 10 years. And then President Obama appointed Merrick Garland, and then we changed it back to 20 years. And then it went firmly to press, and so we couldn't change it. Obviously it was already in print as of last week. So I don't know, we haven't discussed what number we'd come up with for our prediction now, but just to say, it's tough making predictions, especially about the future. Just want to say two more things. One is about Corinna's views about, the theme of legitimation. And she said it so much more beautifully than we did. I wish that we could have stolen some of your stuff, too, like the idea of disowning death. That's a beautiful way of capturing what we describe as legitimation, this idea of facades and the way in which they make people more comfortable so that we have executions without any killers. That was really a very evocative way of explaining what our theme is, that we have so much law and yet so little to show for it. My metaphor was going to be much less eloquent. I was going to say it's like those restaurants that, offer you just tons and tons of food. That's terrible, so that's kind of like the Supreme Court's regulation. There's just a lot of it, but it doesn't do very much. So I have to say, I love an elegant writer who can convey the idea better than me. And finally, the issues of race. This is one of the things that led Jordan and me to want to write a book to reach beyond the audiences we usually reach. I said to one of my students, I don't know if that student's here, I once said, we want to reach beyond the 12 people who read our law review articles. And the student very earnestly said, oh, Professor Steiker, I'm sure 25 people read your law review articles. And so I was being self-deprecatingly modest. And She was being more realistic. So, but the idea of writing the book was to try to reach a broader audience because it strikes us how how much people understand the modern American death penalty in a historical vacuum. And they don't understand how deeply it's inscribed with the sordid racial history of our country. And this was brought home to me last night, where we took the panelists who are speaking today to see a show in the South End of Boston, a musical about the Scottsboro Boys case, Powell versus Alabama, 1932. 9 black teenagers, it's now acknowledged, falsely accused of raping 2 white women, eventually pardoned by the state of Alabama 80 years later, but leads the court for the first time to make constitutional law about the death penalty. And there was a talk back after the show, and the producers of the show asked the audience how many of them, this is in Boston, how many of them had heard of the Scottsboro Boys case. And only the panelists from this conference raised their hand. So that was sort of the impetus to write this book, and we're hoping that if it does reach 26 or 27 people, that will be well worth it. Thank you.
I want to join Carol in just thanking the folks who have come to the conference to speak about the book and to talk about the death penalty, and for those of you who have come today. I just want to respond a little bit to some of the things that were said, all very helpful. First, just to sort of be humble about our contribution on what we think is the expected path to the death penalty. I think Michael Meltzner is right that the brilliant strategy of Tony Amsterdam and the Legal Defense Fund was to say that there was this incredible gulf between what people are willing to, accept in theory and what they're willing to actually do. The language he used, what the American conscience will allow the law to say versus what the American conscience will allow the law to do. I think that our explanation of the route to constitutional abolition is really just a further elaboration of that theory, that ultimately what's going to lead to the constitutional end of the death penalty is that, despite statutes remaining on the books, despite referenda in places like, California and Nebraska and Oklahoma, the bottom line is it's a much better indication of what the American people will tolerate to see death sentences and executions. And as those death sentences and executions continue on their precipitous decline, I really don't think it's going to matter what the referenda say and what the statutes say. I mean, Steve Bright's, famous for saying that the support for the death penalty is a mile wide but an inch deep. And I think that the shallowness of that support is reflected in the decline of the practice. So the chapter in which we sort of try to work through the doctrine and the state of the world and explain why we think constitutional abolition is, the capacity for constitutional abolition is sort of in the cards, really just goes right back to the Boykin insight that there's a constitutional requirement of some kind of consistency between the law on the books and the law in practice. Evan's comments about the sort of serendipity of the death penalty jurisprudence and then sort of the odd and unexpected consequences of constitutional regulation of the death penalty. I mean, we learned a lot from Evan about what produced Furman and what produced Gregg, and he really has, made it clear in a way that I don't think it was clear before his book at all, that those decisions were not the product of well-considered jurisprudential collective thinking, but the product of a lot of somewhat raw and unprincipled compromises. And so I think of our book as carrying on the mission that Evan started. Evan shows how the law was produced in a somewhat haphazard way, and we try to trace the consequences of that law. And it's not surprising that a jurisprudence that was built so haphazardly from the inside turned out to have consequences which were as unexpected and haphazard on the outside. Like Carol, I think Corinna really eloquently describes the phenomena that we describe in our book as sort of the legitimation of the death penalty and the way in which the facade of extensive regulation freed people in ways to act without responsibility in the capital decision-making. And it just occurred to me when I was listening to her remarks, we treated the issue as sort of this somewhat unique circumstance in which extensive constitutional regulation inadvertently propped up the death penalty when that wasn't the expectation. But just listening to Corinna, it just makes me realize that this is a broader and deeper phenomena, that what law does, not just constitutional law, but what law does, and this is Robert Cover's insight, is it masks and allows for violence. That the law, in a way, is something that helps distance us from things that are ugly and hard, and that the death penalty jurisprudence is a particularly lamentable instantiation of that general phenomena of the way in which law covers and conceals and enables untoward results. And Link Kaplan's, we're very grateful for Link Kaplan's generous treatment of our book. Some people have said to us, God, how did you get Link Kaplan to write that? You must owe him like a car or something. You couldn't have, your parents couldn't have written something as laudable. And I assured him that our parents certainly would not have written something as laudable. When we first sent a draft of the book to our mother, who read it, pretty quickly, we got something back that basically said, I read a lot of nonfiction, and it's just a little bit dry. And so we almost changed our inscription from "for our first teachers" to "for our first critics." But when Link had said before this conference he was going to talk about the sort of moral dimension of our work, because so much of the book talks about how pragmatically the death penalty has declined and how it's going to be sort of prosaic concerns about cost and inefficiency that ultimately doom the death penalty. And I think Link is right to insist that there is a sort of deeper moral dimension to our criticism. Part of that dimension is really the concern about revealing the role of race in the American death penalty. And in the book, we openly lament the extent to which even constitutional abolition will likely continue to conceal the role of race in sustaining the death penalty. Listening to his comments today, it made me think also, it's not just that the death penalty is sort of soaked in American racism. It's that I really have come to believe, and this does not come out in the book really that much at all, I really come to believe that the biggest problem with the death penalty is inequality. And it doesn't just have to be along racial grounds. I think there's a real deep connection between concerns about equality and thinking about people as, equal beings that is at the heart of the moral critique of the death penalty. Sometimes we talk about the moral critique as, inappropriate state power, the suffering it imposes on individuals. But I think at bottom there really is sort of a deep concern about equality, and that's what explains why the current practitioners of death penalty around the world are countries that don't have a commitment to equality. And it doesn't just have to be racial equality, it can be political equality, it can be sex equality, I think that if we were going to sit down and write some of the closing chapters again, I'd want to explore more deeply that moral concern and how that moral concern has been sort of submerged in the way in which the court interacted and addressed the death penalty, and that it's a lamentable aspect of the jurisprudence. Thank you.
So, because of the enormous and laudable discipline of this panel, for which I take full credit, we have about 20 minutes left for questions. Yes, Professor Levinson.
Perhaps because I went to Stanford and was very much under the influence of Tony Amsterdam, that I'm asking this question, because it does seem to me he's in one way the root of omnipresence much of this discussion. And Jordan mentioned his tactical brilliance, but it does seem to me that one difference between Michael's book and Evan's book is that for Michael and for many of us, Tony was an unequivocal hero, whereas in Evan's book, he's a distinctly tragic hero. And if there is a tragic flaw, arguably, it was a certain kind of refusal to compromise with regard to the litigation. And given, I'd just be curious to know your reflections on this truly remarkable figure in terms of the history of thinking about the death penalty, litigating the death penalty, how one evaluates his legacy in 2016. And it may very well be that only those of us over 50 know who Tony Amsterdam was. But, still.
Just before you answer, can I say that we're streaming this, so we're going to ask people to use mics when they speak in the future. And just to repeat the question then for the people who may be watching this, the question is for Mike Meltzner and Evan Mandery to reflect on Tony Amsterdam's legacy and the different ways he's portrayed in each of your books.
And to clarify, it came from someone who knows almost nothing about constitutional law, complete outsider.
That was Sandy Levinson who asked the question.
Well, I'll try. It's a very long answer that I can't give because there'd be no other speakers or questions. So this is going to be a highly imperfect answer. I hope there's another opportunity to continue it with this guy who doesn't know anything about constitutional law, so I can help him. First of all, I associate part of your question to comments about his argument in Gregg, where, and I hate that this is maybe inside baseball for some, but if you read some of the wonderful books out there, maybe you can figure it out if you're troubled. Anyway, he was asked, what was it, Justice Powell asked him, what was it, a 747 or something like that, bombed, and would you find the death penalty, some horrible example like that, would you find the death penalty appropriate in that?
Commandant de Buchenwald is the one that Tony...
Yeah, something like that.
Well,
and
when it's Nazis, one just as a
and he said, basically, no, you couldn't execute somebody in that situation either. And Evan's researches show how shocked some of the critical justices were at that answer. I don't think he had any choice. But even underneath that, the notion that some political scientists floated that he made the great error by answering that way, I think is absolutely ridiculous. I think the case was lost anyway. And the notion that an answer in oral argument determined the result in cases before the court in 1976 is totally unpersuasive to me. As to the larger issue of Tony, being a tragic figure. No, I think he is an extraordinary person, and in all my contacts with him, it never crossed my mind that there was anything tragic about him, and I don't really see how the implicit in the question is somehow or other that some of his flaws, and of course he has them, led to the 40 years of misery and foolishness that have followed. And I just don't see the connection. Now, Evan's turn now. But it's a longer conversation.
Yeah, I mean, I think it's a great question. I mean, because I was an outsider to this history, I mean, I have a reasonably objective, an outsider's perspective on it. I've started working on a book about McCluskey, and it's clear even 10 years after Greg that Tony was still the looming titanic presence over this movement. And, you know, most of the actors are extremely devoted to him. I don't say this critically. I love Michael. But I've said to people, Michael loves Tony. And, you know, I've been blessed to get to know Michael over the years, and I did through the course of my book. And I think he doesn't come across as a tragic figure in my book, but maybe Tony does. He comes across as a complicated figure. And I did try to ask some questions in the book that I think are legitimate. I've heard him say that bit before. That seems to me a straw man. I've never heard anybody suggest that Tony lost the case by virtue of his oral argument, or anybody even think that oral argument is going to decide a case. I do think there are some nuanced, very inside baseball moments where he did make decisions that might have changed the path. And there are people in the LDF universe who had very different emotional reactions to some of it. So I think Jurek versus Texas is a very complicated decision. There are a lot of points. Actually, you echo this in the book. I think that tension between people who represent the client and movement lawyers is a very real tension. I just want to say it's on my mind, and you raised it in the book, about the nature of remonstrations. I don't know if you ever feel that I've done this. I've never formed the thought that there was a moment where LDF should have sat down and foreseen, or that Tony should have foreseen the next 40 years. I mean, these are heroes. These are people who lent assistance where no one, not even the ACLU, would step forward, and expanded their mission beyond what the traditional reach of the NAACP was. They're unqualified heroes. I've said this all the time, that it would have been thrilling for me to have been able to work as a lawyer there, and I didn't really enjoy being a lawyer all that much when I was in private practice, so that says something. But I do think, and you guys invite this, I thought in the conversation, I think you make a understandable scholarly, it's a scholar's instinct to try to draw some generalizable lessons, both about litigating issues before the Supreme Court and the interplay. It's a little bit the hollow hope argument, right? So was LDF ahead of the time? Was it on balance a positive or a negative? What happened? And I mean, you draw the analogy to Roe, and it's been on my mind. I've been saying this to my wife for probably about 10 years. I was wondering whether it could carry a book, and it is so much on my mind today. One thing that Roe v. Wade changed was it basically put the Democratic Party in a position of whether or not that was going to be protecting that decision was going to be a centerpiece of the platform. So it accelerated an argument beyond, obviously no question on the merits, but where it naturally would have arisen. And I feel that. I feel the consequences of that today. I don't think those questions are personal. I just think they're natural to ask, and you know, we're feeling bad, and I might feel bad about that today without thinking that anybody made it purposefully.
Can I just say, I share your perspective on Roe, although I wish that Reva Siegel, who is supposed to be here today, could be here, because she disagrees with us, at least sees a more complicated story about Roe and how Roe punctuated a process that was already happening in the political sphere rather than precipitated the kind of conflict that we see today. I tend to think that may be true, but it's still what it did is it concentrated the political conflict that was already in existence around the Supreme Court. So the Supreme Court became a focal point of the political conflict in a way that it hadn't been up to that point. But I wish she were here to argue with. Unfortunately, a family emergency, so she won't be here. But I hope that won't keep any of you from coming to hear more from our last panel, where that constitutional law professor who knows so little, Sandy Levinson, will be speaking about these issues among others.
Can I just add that at the core of this is the notion that if cases were not brought, the death penalty would wither away. There was absolutely no political force in that direction in the 1960s and 70s in the United States. It really reminds me of the argument that opponents of Brown made. Oh, well, if you hadn't done this and had all these troubles that emerged from Brown 2 and school desegregation, why things would have changed. It's just not an argument that ever made much sense to me. These things don't wither away. So LDF, did its best. And if tragedy is not doing it perfectly, yeah, he's a tragic figure, and I'll get on the same train. Otherwise, I think it's more heroic than tragic. And I don't know who's the philosopher here will tell me that probably all heroes are also basically tragic figures. Yeah. Thank you.
Other questions? Randy. Can you get the mic?
Thanks. It's not a question so much about the Supreme Court, but I noticed from the program that this is going to be we're not going to have the authors on panels again. So
hey, Randy, is that mic on?
Is it on? Is it on now?
Now it's on.
Okay, here's my question, and it doesn't have to do with the court, but it has to do with the authors of this great book. We have an administration going out. I wanted to know about your views with respect to the outgoing administration and their handling of capital punishment. So in this city right now, there's a jury deciding a death penalty case. A year ago or more, there was the bombing case. It was up to the Attorney General of the United States to decide whether the federal government was going to seek the death penalty. The Attorney General of the United States said he was against the death penalty, but he sought it. What is your response to the outgoing administration and the way it handled capital punishment?
You need to make clear it's another shockingly unknowledgeable observer who's asked the question.
I have less of a strong opinion about the Obama's administration, the death penalty, than I do have a firm belief that it doesn't really matter what's happened at the federal level with the death penalty. I think it's you would think because it's the federal government that it would have this high level of visibility. I feel as though the death penalty has not been a particularly visible topic during the 2 terms that Obama's been in power. I think the one place where where the federal government might have a significant role in either speeding up the end of the death penalty or delaying the end has to do with a very technical inside baseball question about whether or not states become opt-in states for accelerated federal habeas review. And I feel as though the Obama administration has not done what some other administrations might have done to speed up that process, which I think could be consequential. So to me, I just don't have a strong view. It's hard to imagine a world in which the federal government doesn't seek the death penalty in the Sinarov case. I mean, it's, to me, it's, I can't imagine an administration that would have made that choice. The federal death penalty remains such an inconsequential part in terms of just the numbers of people on death row. I think there have been 3 federal executions in 50 years. The federal death penalty, if the federal government were a state, it would be a marginal capital jurisdiction. And so even though there's a lot of attention to federal actors, it just doesn't carry the same weight that other federal decision-making does in other contexts.
Yeah, I think, the federal death penalty, especially the Boston Marathon bombing, the Tsarnaev case, is overdetermined. One of the first things the Criminal Justice Policy Program did was we brought in, while the Justice Department was putatively considering whether to bring capital charges in that case, we brought together a federal capital prosecutor and a federal capital defender here, filled the Ames courtroom, and asked whether the federal government would or should bring death penalty charges in that case. And there was disagreement on the should. There wasn't no disagreement on the would. It seemed like, and in fact, we have another brother who's a lawyer, a very progressive lawyer, used to be more liberal than now, said, I don't get it. If we have the death penalty, isn't this the kind of case that it's for? It's kind of hard to imagine the Obama administration or any administration not using the punishment when it was available in a case in which, this is terrorism, a child was killed, a cop was killed. I mean, one of these things is usually enough. Weapons of mass destruction, bomb it was in a public place. So, would I have preferred it? We're against the death penalty. Would I have expected it? No. I was asked for some retrospective that one of the Harvard publications was doing on the Obama presidency, to ask what surprised me, what disappointed me, and I did say that what disappointed me was that the Obama administration, the president himself, didn't take a stronger stance on criminal justice issues, on mass incarceration, on race issues. He said some things and he did some things, but they were relatively modest. Nothing as dramatic as not defending the Defense of Marriage Act, evolving on gay marriage. There was no such evolution. Now, however, I'm kind of grateful that the Obama administration didn't stake out criminal justice as one of its major things, because now it's not associated with them as something to repudiate. So I don't know. I'm grasping at silver linings here, but that was something that had disappointed me, though not surprised me, and now I'm not even that disappointed. So.
I have a question. So I want to press a little bit more on what happened last week, and you've all touched on it. Michael, more optimistic. Evan, a little bit more pessimistic.
Whoa, patience.
Patience.
Not optimism.
Sorry, patient. We'll call it patient optimism, right?
Very different.
Okay. Sorry.
Your cancer won't kill you for a few years.
Okay.
That's patience.
Okay.
With an NTS.
Optimistic in a Tolstoyan.
Yeah, I was going to say, now
you.
gloomy, the meter has changed, now gloomy patience. Karina, you talked about, nobody having responsibility for the death penalty, so it raises the question, who has responsibility for ending the death penalty? Link, you talked about the moral underpinnings. So I sort of have 2 questions. One is, the thing about last week is that it wasn't just a shift in the pendulum, but it was a shock. And we all came away from it feeling like we had missed something, right, in this country, and that we're living in well, I shouldn't say we, but but I did, and I think many of us did, that the country we're living in is not the country we thought we were living in. And so what does that tell us about where we are in terms of abolition, the story of abolition, right? And then the second thing is, you've talked a lot about the Supreme Court, and you adjusted your prediction based on the justices of the Supreme Court. Is that the only avenue? Should we be thinking about a different avenue? If the support is a mile wide but an inch deep, Are there other political avenues? So what did we miss, and what's the way of the future?
Wow, that's a hard question. But one of the things that I was encouraged by before the votes were in was how the death penalty actually wasn't much a part of this election. I mean, because of Bernie, it was on the Democratic platform and hadn't been, I think, since 1972, right? Right? So, you know, I looked at that, and frankly, when it made the platform, the Democratic platform, I remember saying to a couple people that I was talking to, I'm really worried about that because there's a lot of progress being made in Texas and elsewhere in sort of the grassroots, just kind of shutting it down. Virginia, I'm from Virginia. Virginia used to be, you know, second to Texas only, and it's pretty much shut down in Virginia. So I was a little, I share Carol's sentiments. I mean, I was a little afraid. And I also thought the Republican strategists, well, anyway, but, you know, I thought they're going to be looking for wedge issues. And going back to the death penalty and like soft on crime, is this going to give, just our taking a stand, Democrats taking a stand on it, is that going to give some power to that? And it didn't. It just wasn't there. And so, you know, I tell you what I meant to say when I first walked up, especially in the wake of some others, is I still believe. I still believe. And the fact that that of all the various things that came up to distinguish the Republicans from the Democrats, that the death penalty wasn't one of them, that they didn't go there, I think spoke volumes. I'm sure somebody looked at it and they were like, man, don't push on that button right now. And so that gives me hope. I also think, you know, despite what happened in Nebraska, which is just super tough, that as the death sentences continue to fall, and the capital defenders keep doing an amazing job, and it just gets so prohibitively expensive. You know, how much is an execution worth? That's where it is. I'm afraid it's not going to be on ideological grounds as much as I'd love for it to be. But I still believe, and that's the reason. What it's worth.
So
We have just a minute or two left.
One of the meta themes that comes out of the election is the threat that politics makes to law. And that's personified today by the announcement that Jefferson Beauregard Sessions III will likely be the Attorney General. But the death penalty is one of those areas of the law where, to diffuse the tension, to find some common ground, the court has explicitly turned to politics to resolve the legal question. So it's the counting of states about abolition of the death penalty for people under 18, for those who are intellectually disabled, and in other ways. And so one possibility is that the court operates on its own timetable and with its own momentum. And Justice Breyer's important dissent is hanging out there, and it's now a book for those of you who don't like to read in the legal volumes. You can get a hardcover. There are 4 justices likely who, if the right case came along, would want the court to consider it, and it will be, again, up to Justice Kennedy to decide on his understanding of dignity and how it applies to this area of law, and that's a possibility. Now, obviously, there's a seat open, and who fills it will have a role to play, and they may be as vehement an advocate for the death penalty as Justice Scalia was, but this is an area where the theory of contingencies, of how unpredictable this area of law is step by step, really makes sense to keep in mind. There's a possibility, but I'm not certain I bet on what would happen in the next 2 or 3 years.
Just very briefly want to say, look, I mean, what the stakes are here, right? Everybody understands the death penalty is ending. The question has always been about how southern outlier states are going to be brought into conformity with evolving standards of decency. That's the small point of discussion here, whether or not the Supreme Court was available as an avenue to bring Texas and Alabama kicking and screaming into the 21st century. And I think the discussion here is whether or not that window is closed. I did, in the election, just want to draw a very quick reference to something you said. Robert Weisberg, on my list of 3 articles I'd read, Deregulating Death is one of them. And it has implications well beyond the death penalty context. It's about using the law as a mechanism to tame existential moments, to make people feel comfortable with morally problematic acts. And longer conversation for a different panel, but I see clear threads of that in people's votes. I don't believe that surely there are racists and people who embrace the racist components of Trump's message. But I think what most people had was a willingness to tolerate racism. And I think that ability, when you confront somebody with, you do realize who you voted for, that existential soothing that they get, and what they get it in this context is from alternative news sources, and that to me is the whopper that makes me in my current emotional state.
My last words, although I'm glad there was no Dukakis moment in the election, and it's nice to have a platform, although both candidates were supporters of the death penalty, the winners in this election, the winner was othering. The winner was vulgarity. In a world where othering and vulgarity and a form of inhumanity have won the election, I don't think you can be very optimistic about what's going to happen next.
Well, on that sobering note, please join me in thanking all of the fantastic panelists.